Today I am appearing in front of you with another part of fundamental rights and fundamental duties in the series of our Constitution. Now I shall talk about the certiorari. Certiorari is a type of writ which is preferred before the Honorable High Court or Supreme Court of India. Briefly speaking, therefore, while prohibition is available at an earlier stage, certiorari is available at a later stage. On similar grounds, the object of both is to secure that the jurisdiction of an inferior court or tribunal is properly exercised and that it does not usurp the jurisdiction which it does not possess. The conditions necessary for the issue of the writ of certiorari are: there should be a tribunal or officer having legal authority to determine questions affecting rights of subjects and having a duty to act judicially. Such tribunal or officer must have acted without jurisdiction or in excess of the legal authority vested in such quasi-judicial authority, or in contravention of the rules of natural justice, or there is an error apparent on the face of its record. The Supreme Court early took the view that the writ of certiorari would not issue against purely administrative action. It would issue only if the authority has a duty to proceed judicially, that is to say, to come to a decision after hearing the parties interested in the matter and without reference to any extraneous consideration. But later decisions have obliterated the distinction between administrative and quasi-judicial bodies. The current view is that even if the governing statute does not require that before making an order affecting an individual, he must be heard, such a requirement would be implied by the court where the right of property or some other civil rights of the individual is affected. To omit to do this is to deny natural justice, and in such cases the court may quash the so-called administrative decision by means of a writ of certiorari under Article 226. A tribunal may be said to act without jurisdiction in any of the following circumstances: where the court is not properly constituted, that is to say, where persons who are not qualified to sit on the tribunal have sat on it and pronounced the decision complained against; where the subject matter of inquiry is beyond the scope of the tribunal according to the law which created it; where the court has assumed a jurisdiction on the basis of a wrong decision of facts upon the existence of which the jurisdiction of the tribunal depends; where there has been a failure of justice either because the tribunal has violated the principle of natural justice or because its decision has been obtained by fraud, collusion and corruption; when the decision of an inferior tribunal is vitiated by an error apparent on the face of the record, it is liable to be quashed by certiorari even though the court may have acted within its jurisdiction. Error in this context means error of law, where the tribunal states on the face of the order the grounds on which they made it, and it appears that in law these grounds were not such as to warrant the decision to which they had come. Certiorari would issue to quash the decision. In all such cases, a high court can issue a writ of certiorari to quash the decision of the inferior tribunal, and the Supreme Court can also issue the writ in such cases provided some fundamental rights has also been infringed by the order complained against. This is all about today's part of fundamental rights and fundamental duties. Thanks, regards.